Professor Wang Jiangyu from City University of Hong Kong, and he's also the director of our Center for Chinese and Comparative Law, which is, of course, the host for this event. Professor Wang is an expert in public international law, international economic law, so he will have some very interesting views to share in these areas. Jiangyu, please.
Can you hear me? Yes. Okay. Thank you very much. Let me share the screen first. Okay. Do you have it? Okay. Well, first, a very warm welcome to all of you. Thank you very much for coming. I would also like to thank my colleague, Professor Liu Qiao, is a leading authority on international commercial law and contract law in this part of the world. And as a center for Chinese and comparative law, which aims to become one of the world's leading centers in these areas, CISC fits perfectly in our research scope, because it's not only about the very nature of Chinese comparative law. It can also showcase our contribution as a research center in Hong Kong to the Hong Kong society. I'm not a CISC expert. Actually, I know something about the CISC many years ago. Actually, my thesis for my master study was about CSG, but I left that area a long time ago for more public international law stuff. Today's topic is also suitable for me, because the application of CSG in Hong Kong is probably essentially a public international law issue. It is about the adoption of an international convention in Hong Kong. There are some special difficulties. There are some legal barriers there, which come from two legal facts. Number one, Hong Kong is a separate jurisdiction, but it is politically a part of China. It is under Chinese sovereignty. And number two, the parties to CSG are made very clear that they must be contracting states. So they must be states in international law. And in this regard, the CSG is in stark contrast with some other international economic law agreements, such as the WTO agreements, right? So the WTO agreements permit countries, jurisdictions to be a party, and it was made clear in the WTO agreements that countries do not necessarily refers to sovereign states. So for that reason, Hong Kong is a member of the WTO as a separate customs territory, but it cannot automatically become and cannot join CSG directly. The arrangements with respect to Hong Kong's membership in international agreements, Hong Kong's participation in international agreements were already made in the basic law. When it was made in 1970s. In my presentation, I will first set out the law, the principles in the law about the different scenarios that how an international convention can be adopted in Hong Kong, especially those which were signed by the sovereign state, the People's Republic of China. And I also discuss a case which very much reflect the diversified perceptions about how international treaties should be applied in Hong Kong, which is actually a Singapore case, and then I will briefly discuss about the implications on the adoption of CSG in Hong Kong. So on how international agreements international treaties can be generally adopted in Hong Kong from the perspective of public international law. They are the basic law, which was already mentioned by Mr. Peter Wang in the first presentation, which is the Article 153 of the basic law. Article 153 envisages three scenarios, three situations, on how international convention can be applied in Hong Kong. So the law is there. I would like to break the law, break down the law into three situations. So the first one is the consultation approach. So for those international treaties to which the PRC, the People's Republic of China, is the state party, and and only states are allowed as a party, then the central government will decide whether that treaty can be applied in Hong Kong in light of Hong Kong's needs. And it's also required in Article 153 that they have to consult. The central government has to consult the Hong Kong SAR government, so seeking the views of the Hong Kong government. So that's the first model, the first scenario. The second one is continuation. So this situation encompasses those international agreements to which Hong Kong was already a party prior to its return to the Chinese sovereignty, and the People's Republic of China was not a party. So and those international conventions are already applied in Hong Kong. So those international conventions can continue to apply in Hong Kong, and the PRC accepts this and recognize this. So that's the second situation. The third situation is actually the more controversial, more complicated situation is the authorization module. So regarding other relevant international agreements, which are the words used in the basic law. And so if it's perceived to be necessary, if necessary, then the central government, the Central People's CPG refers to the Central People's Government. So the CPG will authorize or assist Hong Kong to make appropriate arrangements to make Hong Kong a party or a member to that international agreement. So there are actually two phrases here which are subject to further interpretation, and there are different interpretations. The first one is what does it mean by other international agreements, right? So the common understanding is other international agreements refer to those which are not referred to not covered by the first situation, namely those are not signed by the PRC, or those which were not implemented in Hong Kong. So all other agreements should be regarded as other international agreements, right? So one could certainly argue that the CSG is such an international agreement, right? And the more difficult part is how to understand making appropriate arrangements. So not many meaningful precedents or guidelines in this regard, but we can infer from some writings of the PRC diplomats, of the legal officers of the Ministry of Foreign Affairs, such as the writing of an legal expert in the Ministry of Foreign Affairs, Mr. Ma Xinmin. And he said that it could refer to a situation that the PRC, right, so the central government can join a treaty only on behalf of Hong Kong, right? So for those agreements which requires contracting states to be the parties. So China can join the treaty only on behalf of Hong Kong. That agreement only applies to Hong Kong, and China can have the contracting party requirements modified to suit to Hong Kong's situation, to allow Hong Kong to join that international treaty as a non-sovereign entity. So that's but those are the scholarly interpretations, although they are made by the PRC, legal officers, and this has to be qualified by another provision in the Basic Law. An official understanding, unofficial understanding of the Chinese government, again, because it's I call it unofficial because this view is made by the Chinese officials, the legal officers on different occasions, speeches, statements, press conference, but not any. But not in the form of legislation or a legal document. So the Chinese government actually intends to distinguish between agreements which are related to foreign and defense affairs with those agreements which are not related to foreign and defense affairs. So the assertion is any international treaty which is related to foreign and defense affairs should be automatically applied in Hong Kong. Right? And for those which are not related to foreign and defense affairs, then you deal with such a treaty non-related to foreign and defense affairs, according to Article 153. But this is it's an interesting interpretation. Of course, it doesn't apply to the case of CSG because CSG is certainly not related to foreign affairs or defense affairs. And apart from that, there's also a catch-all provision in the Basic Law. Article 20 of the Basic Law allows the central government to delegate power to the Hong Kong government, so to allow it to do almost anything at the international level, as the international entity. This could probably include the power to be a party to an international agreement. But this is subject to the requirement of the international agreement itself, whether it can accept non-state parties. Of course, we shouldn't forget that Hong Kong has also, under the Basic Law, the Hong Kong government has the Hong Kong SAR has a certain treaty-making power. So in relation to economic issues, trade issues, financial issues, monetary issues, so it can be parties to those agreements in relation to those areas, as long as they are covered by those areas specified in the Basic Law. So this is Hong Kong's own treaty-making power. Of course, this again has to be subject to the requirement of the international treaty itself, which regarding the qualifications of the contracting parties. Right? So this is basically the principles enshrined in the law, in the Basic Law. But the international perceptions might be very different. There's actually recently a landmark case, a very high-profile case, rendered by the Singapore Court of Appeal, regarding whether an international agreement signed by the PRC, by the central government, can be applied in Hong Kong. The Court of Appeal, the Singapore Court of Appeal, decided that as long as it's not clearly indicated otherwise, and PRC agreement should be applied to Macau, and Macau is actually in the same situation as Hong Kong, and based on the principles of public international law. So in this case, in the Sandham investments versus laws, democratic republic case, the Singapore Court of Appeal made this decision on the ground of certain public international law principles. The first one is the moving treaty frontier doctrine provided in the Vienna Convention on the Succession of States in respective treaties, which provides that if an territory in the past is not part of sovereignty, not the part of the state, and now becomes a part of the state, then you have to move the treaty frontier, right, to cover the new territory, which is actually very much based on common sense. There are conditions to fulfill. The conditions are actually two conditions. So the first one is if the treaty itself has a different intention, or if the intention can be established otherwise, that the parties do not want to apply a particular international treaty to the new territory. And also you have the doctrine of the entire territory in the Vienna Convention on Law of the Treaties, that once the state makes an stand up to an international treaty, becomes a party to an international treaty, then unless otherwise indicated, your entire territory should apply that treaty. In this particular case, in the Sanlam case, the Chinese Ministry of Foreign Affairs actually submitted a letter to object. A letter of objection, because the PRC government does not want its treaties to be directly applied in Hong Kong, not consistent with Article 153 of the Basic Law. It looks to me, and a number of others, of course, that this is a very, very problematic judgment, because it seems that the Singapore Court of Appeal totally ignored the intention of the parties, which is clearly embodied in the design of the one country, two system, and also in the letter submitted by the PRC Ministry of Commerce. So it used a few procedure grounds to override the substance of the relationship between Hong Kong and the PRC with respect to treaty application. So but in any event, this is a significant example which can demonstrate that the international society does not take it for granted that the PRC government does not want the treaties it has signed to be automatically applied to Hong Kong. Right? So a common sense might be that people actually take it for granted that since Hong Kong is now part of the Chinese sovereignty, then whatever China does for it should be applied to Hong Kong. And although this without the due consideration of the special case of the one country, two system, this could lead to undesired outcome from the perspective of both the PRC government and Hong Kong. Because if you apply this logic, then the central government can make whatever agreement for international agreement for Hong Kong. So even without seeking the views of the Hong Kong government, then that will actually destroy the one country, two system at the international level, and in contravention with the one country, two system. So this decision, Singapore Court of Appeal decision, generated the furious response from the Ministry of Foreign Affairs of the People's Republic of China. The legal department of the Foreign Affairs issued a rather stern response. some paragraphs of the response, as the Chinese version here didn't have chance to translate it into English, it actually offers a very precise description of the Chinese position on how international agreements should be applied in Hong Kong. Right? So they very quickly on the implications of this general framework, right? How PRC treaties should be applied to Hong Kong. The implications on the CSG, and because of the one country, two system, we know for sure that the CSG does not apply to Hong Kong simply because it is a PRC treaty. There are legal barriers. The CSG can certainly be applied to Hong Kong by way of Article 153 of the Basic Law. If considered, if Hong Kong needs it, and then the central government can make a decision to apply it in Hong Kong after consulting the Hong Kong government, seeking the views of the Hong Kong government, which is actually essentially an affirmation of the moving treaty frontier rule. So the same logic as the Senate, but in this case you have an explicit agreement between the central government and Hong Kong. The CSG can also be applied to Hong Kong by way of Article 93. Although if you look at the details, it may be very questionable. Charles and I actually had a few very lengthy discussions about whether Article 93 can be applied, because Article 93 requires that a declaration to be made at the time of signature, ratification, acceptance, approval, or accession. But all those points have passed. Right? It seems the mainland government has actually lost the opportunity to make any declaration under Article 93 or to take advantage of Article 93 to make use of Article 93 because the time has passed. So there's also an additional question, even assuming Hong Kong can be the CSG can be applied to Hong Kong by way of Basic Law Article 153. We still couldn't resolve the issue that there is legitimate expectation in the business community to treat Hong Kong and mainland China as two separate jurisdictions. So you basically want the courts in Hong Kong and mainland China to apply CSG for a transaction, for a sale of goods transaction between Hong Kong and mainland China. This does not resolve the issue. It does not resolve the issue. And although Hong Kong has treaty-making power in many areas, mainly in economic and treaty areas, it's difficult to override the contracting state requirement in the CSG. Maybe an appropriate arrangement can be that Hong Kong is made a party of the CSG, made a party to the CSG by way of Article 153. Then an agreement is signed between the Central People's Government and Hong Kong to provide that transactions between Hong Kong and mainland China can be governed by CSG, as if they are two contracting states. This is not a strange case, at least not the first time, because we do have such arrangements between Hong Kong and mainland China with respect to the arbitration issue, the recognition of and the enforcement of arbitral awards. Okay, I guess that's all. Thank you.